Our next speaker is Charlie O'Connor. Now, the significant thing about Mr. O'Connor is that he is from Ottawa. Those of you who are astute will have noticed that aside from our keynote speaker, John Howard, who hails from the great metropolis of Vancouver, all of the other speakers in this series, with the exception of Charlie O'Connor, are from Toronto. So we had sort of thought of Charlie as our resident rustic. And we then found out that not only does he practice in Ottawa, he also practices in Toronto, in First Canadian Place of all places, and lives at Harbour Square. So he has become the ultimate Toronto sophisticate. And just to show you how sophisticated he is, he's going to deal with the whole area of public and private financings in less than 1 hour. Charlie?
I'm certain to let you down on that, Jack. I want to touch this morning in my remarks upon some of the significant changes that the New Securities Act has brought to the process of raising capital in Ontario through the use of a prospectus. Like the 1966 Act, the present Act provides for the regulation of the securities market in Ontario through two principal functions. Firstly, the qualification and registration of the people who are involved in the securities business in Ontario. Secondly, the qualification and registration of specific securities and their distribution in the market pursuant to a prospectus. However, the Act, unlike its predecessor, also controls and restricts access to the secondary trading market in securities previously distributed in reliance on a prospectus exemption. And this is one of the major changes in the Act. This aspect of the regulatory scheme of the Act is referred to as the closed system. And an integral aspect of the closed system is the statutory concept of a reporting issuer in good standing under the Act and the regulations. The obligations imposed by the Act on a reporting issuer, including the burden of continuous disclosure, the insider reporting requirements and trading restrictions imposed on directors and officers of reporting issuers, and the limitations imposed by the Act on trading in securities of non-reporting issuers are matters which must be considered by companies or persons proposing for the first time to raise capital through the sale of securities in Ontario. Similarly, the expansion of the statutory causes of action for rescission and damages available to a purchaser of securities issued in contravention of the requirements of the Act raises important considerations for those persons who are involved in the distribution process. Under the Act, underwriters, directors, those officers who are required to sign the prospectus, and persons who are named as having expertised portions of the prospectus are now liable by statute for damages for misrepresentations contained in a prospectus. These persons may avoid such liability only if they are able to establish that they conducted such reasonable investigations as to provide reasonable grounds for belief that the prospectus in fact contained no misrepresentation. The conduct of such reasonable investigations is the due diligence process. The Act now regulates distributions of securities generally by prohibiting any trade in a security where such trade would be a distribution of the security unless such trade is effected either by means of a prospectus, through the use of a relevant exemption, or pursuant to an exemption order from the Commission. Since March 15, 1981, the Act no longer ties the concept of distribution to a distribution to the public. The term distribution, by definition, includes four basic types of trade. The first is a trade in previously unissued securities. The second is a trade in previously issued securities that were reacquired for the account of the issuer and are being reissued. Thirdly is the trade in securities out of the so-called control block or out of the holdings of a controlled person. Finally, however, and most importantly to the closed system, is the deeming of the first trade in securities acquired pursuant to a prospectus, the resale to be a distribution. Securities sold or distributed by means of a prospectus may be freely resold by subsequent holders of such securities, providing the resale does not itself constitute a distribution. The same, however, is not true of securities distributed pursuant to an exemption. The Act ties the resale into the secondary market of securities distributed pursuant to an exemption to the concept of a reporting issuer in good standing under the Act. The consequences of distributing securities in contravention of the requirements of the Act are substantively different from that which obtained under the previous legislation. The Act provides civil remedies to a purchaser who purchases securities distributed in contravention of the obligation under the Act to deliver a prospectus. The principal civil remedies lie in two statutory rights of rescission, which a purchaser has available to him when a dealer, as that term is defined in the Act, fails to comply with the duty under the Act to deliver prospectuses in the circumstances to which the prohibition in Section 52 applies. Section 70 of the Act requires a dealer who is not acting as an agent of the purchaser to deliver to a purchaser a prospectus relating to the security to be distributed not later than the end of the second day, excluding Saturdays, Sundays, and holidays, following the conclusion of the agreement of purchase and sale with the purchaser for the security. The Act defines the term dealer to mean any person or company who trades in a security in the capacity of principal or agent. For example, if I was selling a share to Mr. Ground here, and I was acting as a principal, I am by definition under the Act a dealer. So it applies to every vendor of securities who's acting as a principal, and not just to investment dealers as one would think in common parlance. So in the context of Section 70 of the Act and Section 130, which I'll come to in a moment, the term dealer extends to an issuer whose securities are being sold by it or by an agent on its behalf. Where, therefore, in connection with the distribution, the Act requires a prospectus to be filed and a receipt, therefore, to be obtained, and such a prospectus is not delivered to a purchaser in compliance with Section 70, subsection 1, the purchaser has a right, pursuant to Section 70, subsection 2, to elect not to be bound by his agreement to purchase the securities. If the prospectus is never delivered to the purchaser, for example, on the mistaken belief that there was no need to use a prospectus and that a particular exemption was available, it is arguable that the section may be interpreted to leave the rescission rights outstanding, as it were, forever. Section 130 gives a purchaser of a security to whom a prospectus was required to be delivered and was not so delivered a right of action either for rescission or damages against the person who sold him the security. The right contained in Section 130 is limited by Section 135. The right must be exercised in the case of a claim for rescission within 180 days after the date of the purchase. In the case of an action for damages, the action must be commenced the earlier of 180 days after the plaintiff first had knowledge of the facts giving rise to the right to make the claim, or 3 years after the date of the purchase. It's no defense to an action by a purchaser either under Section 70 or under Section 130 that the issuer, or the dealer as the case may be, proceeded on the advice of counsel. In fact, in the case of Section 130, the Act provides no defenses, and there is no limitation on the amount of damages which may be claimed, as there is in the case of a claim for damages for a misrepresentation in a prospectus, which is found in Section 126. If one looks at Section 70 in its entirety in Section 130, the preferred view is probably that the right of action that's contemplated by Section 70 is restricted to the situations where, in fact, a prospectus was filed and it was just never delivered to the purchaser. However, the section's not at all clear, and the genesis of Section 70 in its present form, it started out to provide the rescission remedy, which was subsequently extracted from it and put in Section 130, so the statute's not very clear at all. This summary of the rights and remedies of a purchaser of securities under Section 70 and under Section 130 is intended to highlight the importance of ensuring that if a distribution is proposed without the filing of a prospectus in reliance on a prospectus exemption, that the issuer ensure that the exemption is in fact available, and then ensure that it's strictly complied with. The decision to undertake public financing should be made with the full understanding of the prospectus process and its implications to the issuer, the issuer's directors, and the senior officers of the issuer. The Act introduced two important changes to the law in Ontario relating to issues of securities by public prospectus offerings. As previously mentioned, the Act provides a statutory right of rescission. In addition, the substantially broadened civil remedies provided by the Act, where prospectus contains a misrepresentation, have given rise to what's known as the due diligence process. Section 126(1) of the Act provides that if a prospectus, together with any amendment, contains a misrepresentation, a purchaser who purchases during the period of distribution is deemed to have relied upon the misrepresentation, providing it was a misrepresentation at the time of the purchase, and such purchaser has a cause of action either for rescission against the issuer, selling security holder, or the underwriter from whom he acquired the securities, or an action for damages against the foregoing persons jointly and severally with the directors of the issuer, each person who signed the prospectus, and each person who is named as having expertised any portion of the prospectus. The liabilities under Section 126 and the exposure to a claim for rescission are founded on the disclosure document containing a misrepresentation. The Act defines a misrepresentation as being an untrue statement of a material fact, a misstatement of a material fact, or a misleading statement of a material fact. Material fact is defined by the Act in relation to securities proposed to be issued as a fact that significantly affects or would reasonably be expected to have a significant effect on the market price or value of the securities. The purchaser's rights under subsection 126(1) of the Act are in addition to any other rights or remedies available to the purchaser at law. The liability of the issuer under Section 126 is absolute in the absence of being able to prove that the purchaser purchased in fact with knowledge of the misrepresentation. This, however, is not the case for directors, officers of the issuer, underwriters, and professionals who contribute to the content of the prospectus. For this group of people, there are certain statutory offenses available, the principal one of which is the due diligence defense. Subsection 5 of Section 126 provides that a person or company other than the issuer or selling security holder is not liable under Section 126(1) if he conducted such reasonable investigation as to provide reasonable grounds for belief that there had been no misrepresentation and in fact did not believe that there was any misrepresentation. Sure.
I apologize for interrupting, but I have what I'm told is a particularly urgent message from Mr. Richard Lesage from the Federal Department of Justice. I wonder if he could come and see me.
In determining what constitutes reasonable investigation or reasonable grounds for belief for the purpose of these provisions, the standard of reasonableness is that required of a prudent man in the circumstances of the particular case. The origin of the civil liability provisions and related defenses in Section 126 of the Ontario Act may be traced to Section 11 of the U.S. Securities Act of 1933, and a review of the case law under these sections is useful in providing a background to an understanding of the full implications of the due diligence defense under the Act. The most relevant judicial considerations of this defense are found in the cases of Escott versus Bar Chris Construction Corporation and Fiat versus Lisco Data Processing Equipment. These two decisions stress the importance of the role of directors, officers, and underwriters, both alone and together with their respective counsel, in independently testing the veracity of statements of fact that are made by officers and members of management of the issuer on all matters that are considered to be material in an assessment of the value of the securities. While reliance on counsel may be relevant to a demonstration of due diligence on the part of senior management, in cases where good faith and due care is a necessary aspect of this defense, reliance may not prove to be a total defense. Reliance on counsel by issuers and directors should be reasonable considering the qualifications of counsel selected, the extent to which counsel was informed of all relevant facts, and the actions taken as a result of the advice given. Investigations by and the advice of counsel, however, do not serve as a substitute for the due diligence investigations and belief required independently on the part of senior management. Counsel's advice will serve simply as supplementary evidence of the efforts generally made by the directors and senior officers. In the recent decision of the Ontario Securities Commission in Canada Cement Lafarge Limited and Standard Industries Limited, the Commission criticized the inadequacies of the due diligence procedures used by counsel for one of the parties to the transaction. And after stating that the directors are entitled to rely on their counsel, the Commission commented that this does not relieve them from their obligation to ensure compliance with their relevant statutory duties. The Commission went on to note that the directors owed a duty to the Commission, to the shareholders, and to the investing public at large to take great care to ensure that both the letter and the spirit of the Act were complied with. In connection with due diligence, counsel exposed to civil liability in two respects. Firstly, for those portions of the prospectus that counsel is deemed to have expertized. And the most common of these are counsel's opinion as to the eligibility of the securities being offered for investment by regulated institutions such as insurance companies and trust companies, and opinion on relevant tax matters. The second area where counsel may find himself exposed does not arise by virtue of the statute directly, but rather indirectly. That is where counsel either undertakes on behalf of his client to perform some of the investigative obligations in connection with due diligence, or provides advice on certain matters, and in either case does so negligently. In this case, if the client is liable under Section 126(1), counsel may find the client seeking to claim over on the basis of negligence against counsel. Turning now to the prospectus process itself. A person proposing to distribute securities in Ontario without reliance on a prospectus exemption must cause to be prepared and filed with the Commission first a preliminary prospectus that substantially complies with the requirements of the Act and the regulations as they relate to the form and content of the prospectus, and secondly, a prospectus that complies with the Act and the regulations and provides full, true, and plain disclosure of all material facts relating to the securities proposed to be distributed. In each case, the issuer must obtain a receipt from the director. Under the Act, the director is required to issue a receipt for a preliminary prospectus forthwith upon its being filed. The preliminary prospectus is used by the issuer and the underwriter to solicit expressions of interest from prospective purchasers. This process enables the underwriter to make a firmer assessment of how much and at what price it can raise financing for the issuer. While the Act requires at least 10 days to elapse between the issue of a receipt for a preliminary prospectus and the issue of a receipt for the final prospectus, in practice this period is likely to be much larger. If the issuer is a new issuer, the period between the filing of a preliminary prospectus and obtaining a receipt for the final could be anywhere from 6 weeks to 10 weeks, depending upon a number of factors, including particularly the nature of the comments that are received from the Commission staff on its review of the preliminary prospectus. In the case of junior industrial issuers which are coming to the market for the first time, senior management will have determined in advance the need for equity or debt financing, as the case may be, the optimum amount of financing required for the company, and the corporate purposes for the issue. New issuers coming to the market for the first time should be encouraged to convene an initial meeting at an early stage with its counsel and its auditors to discuss the going public proposal generally, with a view to ascertaining the preliminary corporate, legal, or accounting issues that should or need to be taken care of, either prior to or in the course of the preparation of a preliminary prospectus. Matters which should be reviewed by counsel, the auditor, and senior management of the issuer at such a preliminary meeting include the following. First, the benefits and burdens in practical terms of being a reporting issuer, the substance of the prospectus process, the differences between proceeding by way of a prospectus or relying on a private placement exemption. Secondly, and importantly in the case of new issuers, the time commitment required of senior management, firstly during the preparation of the preliminary prospectus, and then during the period between the preliminary prospectus and the filing of the final, to assist the underwriter in his marketing efforts and to assist counsel in dealing with the comments of the Commission staff on the preliminary prospectus. The two other matters which should be reviewed in a general way at an early stage are firstly financial matters, a review of the financial statements required for the prospectus and the extent to which this data is available from the issuer, and a review of the non-financial disclosure matters, which is best accomplished by taking the issuer and the senior officers of the issuer through a preliminary review of the disclosure items called for by the appropriate form of prospectus required by the regulations, which in the case of an industrial issuer is Form 12. The purpose in this initial overview with the client is to ascertain whether you have any so-called showstoppers, that is, material deficiencies from the requirements of the Act and the regulations as to the content, both financial and otherwise, of the matters that are to be included in the prospectus. The regulations provide the Director under the Securities Act with very wide discretion to relieve or permit the omission of matters that may be required by specific provision of the form of prospectus, or matters that, such as financial statements, that may be required but in fact are not available. This discretion in a proper case would be exercised so far as to permit a prospectus to be filed where the only financial document was an audited balance sheet and not even on a comparative basis. I don't know that that's an example that the Commission would want to see repeated often, but again, in a proper case, the Commission can be persuaded to forego what would otherwise be mandatory requirements in terms of both financial and other disclosure. Where you have those types of concerns about the ability of the issuer to comply with the requirements of the Act, these should be raised with the Commission staff, certainly prior to filing the preliminary prospectus, and ideally at a very early stage. If you're not able to persuade the Commission to have the Director exercise his discretion to relieve you from some of the requirements, then it may well be that you would have to opt for raising the required financing by using a private placement exemption. The Commission staff are quite prepared to respond to these kind of problems, but in doing so, prefer that the issuer's counsel file a memorandum outlining the problem and the proposed solution and are then prepared to meet with you and discuss the same. By the time of the initial prospectus meeting between representatives of the underwriter, the issuer, and the respective counsel, the underwriter will most likely have researched the industry in which the issuer is engaged, will have become acquainted with the issuer's position in the industry and its principal products or service lines. Copies of recent prospectuses or registration statements filed by other companies in the same industry will have been reviewed. A review of this material is helpful and necessary for counsel in order that counsel may attain some reasonable understanding of the nature of the issuer's business and the industry as a whole in order to effectively participate in the preparation of the prospectus. Formulating a good working draft of the description of the issuer's business, the risk factors associated with the issuer's business, and contracts which may be material in the context of the securities to be issued requires an understanding of the issuer's business and its position in the industry generally, and this can take some considerable amount of time. In practice, counsel acting for underwriters will find that the underwriter is very cognizant of his role with respect to the prospectus process, both in a legal and in a practical sense. Counsel to first-time issuers, on the other hand, may find it somewhat more difficult to impress upon their client and the directors and senior officers of their client the true substance of the obligations imposed on issuers and directors and officers, firstly by Part 16 of the Act, which deals with prospectuses and distribution, Part 15 of the Act, which deals with distribution generally, and Part 22 of the Act, which deals with civil liability. In some cases, counsel may feel that it is necessary to move beyond simply advising the client and its directors and officers of the provisions of the Act and their obligations thereunder, and taking a more independent role in determining whether or not the standards required by the Act are in fact being met. There are two documents, or pieces of documentary evidence, which are of assistance both to counsel and to directors and officers of an issuer in ensuring that they are complying with their due diligence requirement. The first has to do with what is known as auditors' comfort letters. For some time, it's been the practice in the United States for underwriters to require the delivery to them a comfort letter addressed to them from the company's auditors covering the unaudited financial statements that are included in the prospectus, as well as the financial data that's included in the textual portion of the prospectus. Both the unaudited financial statements and the financial data included in the textual portion of the prospectus constitute non-expertized financial information, and the directors and officers have a liability in respect to that information to ensure that, so far as they are able, that it is accurate. Auditing firms in Canada recently have been prepared to issue similar comfort letters in connection with prospectus filings under the Act. The comfort letter basically addresses four areas. Firstly, it identifies the various financial statements, both audited and unaudited, contained in the prospectus, and generally the scope that the auditors have reviewed and undertaken in connection with the non-expertised financial statements. Secondly, the letter confirms that the unaudited financial statements have been prepared on a basis that's consistent with the audited financial statements contained in the prospectus. Thirdly, the letter would provide some assurance to the persons to whom it's addressed that the financial data that's included in the textual portion of the prospectus has been compared by the auditors or cross-referenced to base financial data in the issuer's financial records. Finally, while a review by the auditors for the purpose of the comfort letter, or for that matter, within the context of their general professional engagement in the context of the prospectus process, would not necessarily reveal a material misstatement of non-expertized financial data, the letter would normally state that nothing came to the attention of the auditors in the course of their review that would lead them to believe any such information was misleading. Such a letter should be delivered prior to the filing of the preliminary prospectus and updated prior to the filing of the final prospectus. The second document that's an important tool to counsel and to directors and officers of issuers is the use of a memorandum and questionnaire for management. It is normal for counsel to provide directors and senior officers of the issuer with a memorandum which attempts to summarize their duty under the Act in connection with the preparation of the prospectus, the distribution of the securities, their potential liability under the Act, and the defenses that are available to them. This memorandum is accompanied by a draft of the prospectus and a questionnaire which directs the attention of each to the particular disclosure items called for by the form that may or should be within the particular knowledge of the directors and officers. This is normally provided to the directors and officers of the issuer a week in advance of the anticipated date for filing of the preliminary prospectus. The directors are required to sign the questionnaire and return it to the company. In addition to the specific disclosure items to which their attention is addressed, the questionnaire requires a written confirmation that to the best of the knowledge of the director or officer, based upon his review of the draft prospectus or preliminary prospectus, the document does not misstate any material facts or omit to state any material facts. Section 54 of the Act requires the director to issue a receipt for a preliminary prospectus forthwith upon its being filed. Following the filing of the preliminary prospectus, Commission staff will review the prospectus and prepare a comment letter, which is sometimes referred to as a deficiency letter, which outlines the staff's concerns with respect to the sufficiency of disclosure in the preliminary prospectus, defects in compliance with the disclosure items or the financial requirements under the regulations, and as a third group of matters, substantive matters relating to the issuer and the proposed issue, such as accounting deficiencies, the inadequacy or otherwise of proposed escrow arrangements, and other public interest considerations. Following receipt of the comment letter, counsel for the issuer and the underwriter, in consultations with the clients, will prepare a written response to the Commission addressing each of the items in the comment letter. This is normally followed by a meeting with the Commission staff in an attempt to settle the comments. The satisfactory resolution of the items identified by the staff in the comment letter or letters is necessary to ensure that a receipt will be issued by the director for the final prospectus. The Act confers upon the director a broad discretion to refuse a receipt for a final prospectus. Section 60, subsection 1 of the Act provides that unless it appears to the director that it is contrary to the public interest to do so, the director shall issue a receipt for a preliminary prospectus, for a final prospectus. Subsection 2 of Section 60 lists 9 areas of public interest, which, if the director determines that they exist, makes it mandatory upon the director to refuse to issue a receipt for a final prospectus. While each of these requires and deserves careful consideration, I wish to touch briefly on 3 of them. Paragraph B of subsection 62 deals with the payment of unconscionable consideration for promotion purposes or the acquisition of property. An interesting decision by the Commission under this section is in the case of Mosport Film Productions and the Securities Act. In this case, Commission staff were concerned that the consideration to be paid to the promoter was unconscionable, or alternatively, that the rate at which he was going to get paid was not in the public interest. While the Commission determined that the amount to be paid was not unconscionable, it nevertheless directed that the rate at which the commission was to be payable to the promoter should be altered. I draw the case to your attention because it's an interesting example of the effective use of the residual discretionary power of the director to require material change in the business terms of a transaction for the protection of investors. The second item in section 60 sub 2 that's worthy of note is Clause E, which requires the director to refuse to issue a receipt for a final prospectus where the past conduct of the issuer, a promoter, or an insider afford reasonable grounds for belief that the business of the issuer will not be conducted with integrity and in the best interest of its security holders. Recently, the Commission staff have relied on this section to recommend that a receipt for a final prospectus not be issued to Gas Metropolitan, Inc., because the Caisse de Depot, who was a controlling shareholder and therefore an insider, had failed to file insider reports with respect to other holdings of public companies whose shares are listed in Ontario. And I just briefly want to quote from the comment in the Commission's comment letter on the preliminary prospectus. And this is the staff's comment. It is therefore our position that it is not in the public interest, brackets see section 60 sub 1, to issue a receipt to an issuer where an insider has failed to comply with the Act. And in connection with that deficiency comment, the question referred by the Director to the Commission was stated as follows. Based upon the foregoing facts, should the Director refuse to issue to Gas Metropolitan a receipt for a prospectus pursuant to section 60 sub 1 or 62E of the Securities Act? Now that hearing is not going to proceed for other reasons. For additional examples of matters which the Commission staff and the Director consider to be not in the public interest under this clause, you should refer to the Notice of Hearing and Review pursuant to Section 8 in the matter of Go Gamma Explorers Limited, which is in the January Bulletin. One other matter in that list of matters in Section 60 sub 2, which may be of particular interest to Council, is Clause I. This clause requires the Director to refuse to issue a receipt for a prospectus where a person or company who prepared or certified any part of the prospectus or is named as having prepared or certified a report or valuation used in connection therewith is not acceptable to the Director. The staff of the Commission have indicated that they are prepared to rely on this section and to refuse to issue a receipt for a prospectus where a lawyer, architect, engineer, or any other person who prepared or certified any part of the prospectus is determined by them not to be acceptable. The grounds for arriving at such a determination have not been enunciated. In connection with the first public issue by Junior Industrials of equity securities in Ontario, it is usual for there to be escrow arrangements restricting subsequent distribution of securities by directors, officers, and in some case major shareholders of the issuer. Section 60 sub 2F of the Act requires the Director to refuse to issue a receipt for a final prospectus where it appears to him that pooling or escrow arrangements satisfactory to him are not in place. The regulations, Section 67 of the regulations, require that any prospectus, any escrow agreement required in compliance with that section should be in Form 17. In fact, as a matter of practice, Commission staff do not insist upon the escrow arrangements being embodied in a document which tracks Form 17. And if you review it, you'll find that it's inadequate for a number of reasons. The Commission is not a party to escrow agreements. And while there are a significant number of matters which should be considered in preparing an escrow agreement, one of the most important and one of the most contentious in dealing with the Commission is the so-called release mechanism, and that is the terms under which the shareholders who deposit their shares under these escrow agreements are entitled to get them back. The Commission prefers an arrangement which leaves the Commission with the discretion to agree or not agree to a release at any particular time. That, as you can appreciate, is not always satisfactory from the perspective of the shareholder who's being asked to deposit his shares in the escrow. And while there are good and legitimate grounds for requiring escrow arrangements, particularly in the case of first-time issuers. Nevertheless, these arrangements should reflect a reasoned view of the issuer and the underwriter of a fair balance between the interests of the shareholder, whose shares would be escrowed, and the legitimate investor interest to be served by an escrow. I prefer, and the Commission in a proper case are prepared to accept, that the release mechanism should be tied to a definitive test that's based upon the achievement by the issuer of a specified level of earnings or earnings per share operative as at a particular date or in stages over a period of years, depending upon the circumstances. It seems to me that kind of a test better achieves the objects for which an escrow arrangement is supposed to be put in place than to leave it to the discretion of the Commission at a future date to determine whether or not it's appropriate that the shares should be released from escrow. One of the problems that the new Act gives rise to in certain circumstances in connection with prospectus distributions is the occurrence during the distribution period or prior to the end of the distribution period of a change in a material fact which would give rise to a misrepresentation in the prospectus document. As mentioned earlier, in the context of the liability imposed by Section 126, it is tied to there being a misrepresentation in the prospectus together with any amendment. And the definition of misrepresentation is tied to whether or not you have a material fact and whether or not it is misstated or omitted to be stated or stated in an unclear manner. The definition of material fact tests materiality of any particular fact in relation to the market price or value of the securities of the particular issuer. The essence of the definition is whether the fact has or can reasonably be expected to have a significant effect on the market price or value of any securities of the issuer. It is important to note that there are two distinctive subjective elements to the operation of the definition. First, where no class of securities is publicly traded, it is necessary to assess the impact as though a class was in fact publicly traded, so that you can assess the impact in the imputed market price or value. Where more than one class of the issuer securities are publicly traded, the reference to any in the definition requires an examination of the effect on the most volatile class. Secondly, the test requires an assessment of what the likely effect would be were the change or fact publicly known. This is often a virtually impossible task, as anyone who has attempted to predict share price movements is painfully aware. When that task is completed, one must then subjectively assess whether such subjectively determined price movement is significant. It's probably wise for counsel participating in an attempt to make a determination of materiality under these circumstances to enlist the assistance of the issuer's fiscal agent, who is at least one step closer to the marketplace than is the lawyer. Section 56(1) requires an amendment to be filed in two cases where there is a change. First, it requires an amendment to be filed to the preliminary prospectus where the change in the material fact is adverse and occurs before a receipt has been obtained for the final. In such case, the issuer is obligated to cause to be delivered to every person to whom a copy of the preliminary prospectus was delivered a copy of the amendment. The section also requires an amendment to be filed to a final prospectus where a material change, whether adverse or beneficial, occurs after the receipt for the prospectus, but prior to the completion of distribution under such prospectus. In either case, the amendment is to be filed as soon as practical and in any event within 10 days after the change occurs. Although the Act is silent on the point, an amendment should also be filed to correct a misstatement of a fact contained in a prospectus. Section 56(2) requiring the 56(1) requiring the filing of an amendment to a prospectus deals only with the case where a change occurs. But what do you do under the Act if, in error, the final prospectus, for example, in fact contains a misstatement of a material fact? And if you do prepare an amendment and file it, what do you do with it? The Act is silent on the point in terms of express direction, other than for Section 126(1), which, in dealing with liability and the causes of action based upon misrepresentation, speaks about a misrepresentation that's contained in a prospectus together with any amendment. If, in fact, you unfortunately find yourself in the position where your prospectus, that is your final prospectus, contains a misstatement of a material fact, and you haven't closed the issue yet, then it's suggested that you prepare an amendment, you file it, and you deliver it to everybody to whom the underwriters have mailed a copy of the prospectus, and delay the closing and hope that the market doesn't drop in the meantime. An additional problem with these provisions has to do with the use in Section 126(1) and in 56(1) of the expressions during the period of distribution and prior to the completion of the distribution. The question is, what is the period of distribution, or when has distribution ceased? And it may be a difficult question in some circumstances to answer. If the securities are being purchased by one or two underwriters on a firm basis, and there are no subdealers in the underwriting group, then an issuer should be able to ascertain fairly easily from those underwriters on any particular day whether or not all of the securities being distributed have been sold. If, on the other hand, as is more common in Canada, particularly in the case of large retail distributions, that the underwriting group consists of one or two managing underwriters, 10 or more members of the banking group, and upwards of 25 members of a selling group, the managing underwriter may be unable to ascertain clearly on a particular day whether all members of that group have sold the dealer's inventory of securities acquired for distribution pursuant to the prospectus. The fact that the managing underwriter or banking group has, pursuant to the underwriting agreement, taken up and paid for the securities does not mean that the distribution process has come to an end. And there's still this hanging potential liability if, before the securities are distributed, a fact changes that makes some statement in your prospectus misleading if it was a material statement, or you discover that you have a misstatement in any event. In one common share issued in 1981 in which I was involved, the market conditions turned down sharply after the issue had been priced, and by the time we came to close, the market price was well below what the public and underwriter had agreed to purchase the securities for. The transaction closed, but it was 3 or 4 weeks before the members of the selling group were able to unwind their liability. That is, were able to distribute the securities to end purchasers. And while that period continues, the issuer and the directors and officers are exposed under Section 126(1) if facts outside their control change to cause the prospectus to be misleading. I'd like to now close by dealing very briefly with private financings. I know that Mr. Emerson in his remarks earlier this morning has touched on it, and I want to deal with just a couple of issues as they relate to the counter or juxtaposition of the public offering. The expression private placement in the context of the Act generally is referable to the raising of capital by an issuer through the issuance of securities without the use of a prospectus. The Act, under the old Act, this was basically related to transactions where the purchaser was someone other than an individual, and the numbers and the shares being acquired had a cost of more than $97,000, or the securities were being sold to persons other than individuals whom the Securities Commission recognized as exempt purchasers. The Act and the regulations have introduced a number of important changes to the private placement alternatives for raising capital. Firstly, there are two new categories of private placement exemptions, the so-called seed capital exemption and the exemption which is presently in the regulations dealing with government incentive securities. Secondly, except for the exempt purchaser exemption, individuals are no longer excluded from the class of eligible purchasers on a private placement. Thirdly, in certain cases, an information memorandum meeting certain basic requirements must be delivered to a purchaser and filed with the Commission. Finally, the introduction of the closed system restricts the resale into the secondary markets of securities issued by reporting issuers through the so-called private placement by imposing certain holding periods in the case of private placements by reporting issuers, and by prohibiting the resale of the securities of non-reporting issuers. The regulations under the Act define an offering memorandum for those purposes where the regulations require that an offering memorandum containing a description of the contractual right of action be provided to a purchaser. In practice in Ontario, if an issuer wishes to undertake a private placement and has enlisted the services of an investment dealer to act as agent, the process which the underwriter will expect to go through and the document which will be produced and be labeled as an offering memorandum will very closely coincide with the prospectus process and a prospectus. In fact, some of the underwriters will not allow their name to be used in connection with a distribution of securities pursuant to a private placement unless, quite apart from the requirements of the regulations, the disclosure document closely resembles a prospectus, provides a contractual right of action even though the Act or the regulations do not require one, and contains a certificate which is substantially equivalent to the certificate of the company on a prospectus required by the Act. One of the principal differences, however, between the private placement process and the prospectus process is that in the normal course, the private placement document, the offering memorandum, is not reviewed by the Commission staff. The question of what escrow arrangements are appropriate on the private placement are settled between the underwriter as agent for the purchasers and the issuer. I say in the normal, that's true in the normal course. In the January bulletin, there was a temporary order issued in the case of Metafuse Limited, and it was a consent order. And what the order basically said was that all trading in the securities of that company should cease, except that the company was permitted to distribute securities in accordance with the seed capital exemption. However, the following conditions were attached to the order. Before the said private placement may be effected, Metafuse must file with the Commission an offering memorandum in a form satisfactory to the director with respect to the securities to be distributed. The order is interesting to solicitors for other reasons, and in that it required, as well as a condition of the order, that counsel provide opinions, both technical, a technical opinion on certain patent matters, and an opinion on the content of the offering memorandum, which I certainly would have thought most difficult for council to do. My final comment relates to the format of prospectuses. For those of you who have had the experience of working on a prospectus that is going to be used in the United States as well as Canada, and have had the benefit of U.S. Counsel's advice as to drafting of a prospectus for use in the United States, you'll undoubtedly be struck by the amount of negativism that creeps into the prospectus. The horror, I guess, of the liability remedies against directors and officers, and the extent to which the courts have been resorted to pursue those remedies in the United States has effectively made counsel and issuers and underwriters very gun-shy. And this has resulted in prospectuses tending to have a bit of a negative tone. It's been pursued to its zenith in one case, which I'd like quickly to quote to you. After commenting that prospectuses are all too negative and it loses its effect if every prospectus cries wolf, that is, the process does. The following is an excerpt from a registration statement filed with the U.S. Securities and Exchange Commission. The present directors do not foresee the possibility of the corporation ever being in a position to pay any dividends, have any assets of determinable value. The continued existence of the corporation is questionable. Bankruptcy may result at any time. Anyone considering purchase of the securities must be prepared for immediate and total loss. No representation is made that the possibility exists that the corporation can continue to exist. The Commission thought this was a put-on and refused to accept the document for filing on the grounds that it was not a serious attempt to register securities. That concludes my remarks.